The honourable member for Edmonton Beverly Clareview.
Thank you very much, Mr. Speaker. This is my last opportunity to speak to Bill 22 in this House, and a bill which exemplifies how out of touch this PC government is. A bill that will and has destroyed almost all trust between First Nations governments and this minister. Mr. Speaker, I don't understand how the minister can lose the confidence of all First Nations and councils within our province, yet still retain the confidence of this premier. Mr. Speaker, the minister's job is to foster strong government-to-government relationships based on mutual trust, the honour of the Crown, and this bill does the opposite of that on both accounts. Before I get into specifics, Mr. Speaker, and I just want to acknowledge, first of all, that our Legislative Assembly is sitting on Treaty 6 grounds, and there are, as we speak, more letters that are coming in and submissions from different First Nations and their opposition to Bill 22. And so, Mr. Speaker, I've been very public, as have the Alberta NDP, in our calls for this bill to be completely withdrawn. The only solution that is going to satisfy the Alberta NDP and most First Nations from Treaties 6, 7, and 8 is if this bill is taken off the order paper and completely thrown out. Mr. Speaker, it's interesting that Bill 22 is only 7 pages long, yet is completely riddled with problems. Almost every section is insupportable. And even the preamble that the government presents a diminished view of the treaty and Aboriginal rights, and rights which need to be clarified that were not extinguished by the signing of the treaties, and instead they're protected by the treaties and should be protected by the honour of the Crown. Mr. Speaker, Section 1 defines First Nations with reference to the Indian Act, which for many First Nations they find that offensive, but it also does not accommodate the First Nations who aren't listed under that and who have reserved lands within the province. Subsection 2 prohibits the creating of a trust in favour of the First Nation, and this is utterly ridiculous. Under Section 26, subsection 3 of the Interpretation Act, singular meanings also imply plural meanings, and therefore the government is expressly saying that this fund will not be used for the exclusive benefit of all First Nations and Aboriginal groups, which, if the intention of this Act and this Aboriginal Consultation Levy is to secure funds to increase the capacity for First Nations to participate in consultation, then all of those monies should be exclusively for that use, Mr. Speaker. Section 3 tells us that the Consultation Levy will be decided behind closed doors in the secrecy of the Cabinet confidentiality. It will not be determined through negotiations with the very people that it directly affects. Section 4 tells us by omission that administrative penalties and outstanding interest charges on unpaid levies will not go back into the levy fund to support First Nations capacity building, but could in fact go into government general revenues and spent frivolously. Section 8 is extremely offensive. According to the Legal Counsel, for Treaty 6, this section should be removed entirely. It's unnecessary in terms of accountability, as I spelled out in second reading and during many of the late-night debates of Committee of the Whole, and it imposes information sharing requirements upon Aboriginal peoples that, again, are not imposed on non-Aboriginal peoples, which, again, all members of this House should be equally offended by this, that you've got one set of rules for one group of people based on race, and you've got another set of rules for other people. Again, an example that I've said a few times, Mr. Speaker, is that if this type of bill was forced upon landowners, they would balk at it, that they must disclose their private agreements between industry and themselves. So how this is possibly included in a bill that forces Aboriginal peoples to disclose is ridiculous. It's also in violation of the UN Declaration of Indigenous Rights, and according to some First Nations, they feel this is in violation of their of the Constitution and of the Canadian Charter. You know, Mr. Speaker, it's kind of ironic because it's the kind of clause or section that human rights lawyers should know and should be aware of and should be opposed to. And I'll leave it at that. Section 9 is a blank check to the minister to do whatever he wants because the decisions are final. He has total power and complete authority and are not subject to review. Last time I checked, we still lived in a democracy, Mr. Speaker. You know, it's anti-democratic and it's unacceptable. Section 10 is another example of a blank check that this bill will give to Cabinet and reserve the powers, including the amount of the levy, which, again, we're debating a bill that is supposed to garner resources to help facilitate and increase capacity for First Nations to consult. Yet the amounts that will be levied are not included in the very bill that this government would like this Assembly to pass. That makes absolutely no sense to me, Mr. Speaker. I mean, furthermore, the fact that some industry, or some of those that are in industry already do provide some financial assistance to certain First Nations bands to help with their capacity to consult. That figure, given to me by the minister himself, was somewhere around $150 million per year. The amount that the government is intending to levy is somewhere around $70 million. And so, although the Levy Act has the intention of providing resources for First Nations to increase their capacity to consult on projects, it's actually going to be, or likely to be, far less than what is currently going to some of the First Nations around the province, which is ridiculous. Mr. Speaker, one of those blank checks that Cabinet is going to get, not only the amount of the levy, but it's how it's going to be collected, how the grants are going to be made, whether or not there'll even be administrative penalties, which raises the point that there is no enforcement mechanism in this piece of legislation. So if a proponent refuses to pay a levy or decides not to pay the levy, there might not be any consequences. As well, Cabinet reserves the right to exempt any proponent or industry from, or an entire class of proponents, Mr. Speaker, from paying the levy, which, to me, that's a giant loophole where this PC government gets to choose which proponents or companies pay the levies and which do not, which does not sound like it's a very fair or equitable system at all. Mr. Speaker, we have no assurances in this bill, as it is currently written, whatsoever, that consultation funding, like I had said, will not decrease, which poses quite a significant problem, considering the minister is touting how beneficial this bill will be. Mr. Speaker, over the past week, we've seen a massive public outcry from different First Nations across the province, from all three treaties. As soon as Bill 22 was tabled, Mr. Speaker, Treaty 8 expressed its shock and dismay. They told us that the bill was never mentioned at their ongoing meetings, including a meeting on May 3rd of 2013 with the minister. Grand Chief Roland Twin had written, and in a letter that's already been tabled to the Assembly over the last few days, that they oppose the new legislation because there was no meaningful and proper consultation. They view it as a continuation of the paternalistic attitude that this government has toward First Nations and that they've struggled against. Treaty 8 feels that this legislation is more likely to hinder than to help, and the minister's complete power that is granted to him under this bill is an alarming authoritarian stance that denies the principles of justice, fairness, and equality. Treaty 6, Mr. Speaker, echoed these concerns, saying legislation came equally as a shock to them. In a letter signed by Grand Chief Craig Mackinac, which again was tabled in this House, he wrote that a meeting with the chiefs of Treaty 6 on May 3rd, there was zero indication that any levy would be placed into law, nor was it mentioned that that law would arrive 5 days later. Mr. Speaker, in this respect, many of the chiefs of Treaty 6 feel that the Alberta government is moving ahead on their own agenda and ignoring the recommendations and the voices of First Nations peoples in Alberta. And the Grand Chief had said in that letter, "Why trust Alberta now?" First Nations will reject and resist this policy. So, Mr. Speaker, this bill is deeply flawed, and the problems are quite substantive. And before I go through those, I just want to mention as well, Mr. Speaker, that a couple of letters that have gone out recently from Onion Lake Cree Nation by Chief Wallace Fox talks about and mentions how there's been no meaningful consultation that has taken place with the Onion Lake Cree Nation on this proposed legislation. There were a couple of documents that they have made public, Mr. Speaker, and I strongly urge the Minister to read these documents if he hasn't yet. But concerns that Onion Lake Cree Nation have, they've not been considered as equal partners. And they ask, where is the meaningful mechanism to reconcile outstanding treaty obligations in the honour of the Crown? They comment on the matrix that this government has developed and how they have their own protocols and processes on consultation, and how with several of the treaties that they have put forward consultation papers, their own consultation policy, if you will, Mr. Speaker, that has been continually ignored and rejected by this government. And I'll read this one line from the letter, which we'll have to wait until our next day to table, Mr. Speaker, but the Onion Lake Cree Nation strongly opposes the perceived jurisdiction that the province of Alberta and the state of Canada has over the lands and resources in their treaty and traditional territories. And so, Mr. Speaker, to talk about I'll talk about at least three of the fundamental problems with the process that led to this bill, and that's part of the major thrust of my opposition to this bill, Mr. Speaker, is the process by which this bill was written. First of all, Mr. Speaker, democracy demands that when legislation is being drafted and considered, the people who will be directly affected should have the adequate opportunity to be consulted, to provide feedback, to have input on legislation that will directly affect those people. Responsible government should also be responsive government. In this session, Mr. Speaker, the Premier has shown that she is not responsive to First Nations or to students or to seniors or to persons with developmental disabilities, and she's refused to hear the call of these people, of these groups, and of the opposition to rethink her budget. Secondly, Aboriginal relations, Mr. Speaker, involves a government-to-government relations. First Nations are not subordinate to the Minister nor to any government. They are equal partners and should be treated in that fashion. By failing to consult with First Nations, chiefs and councils, the Minister has really violated the protocol agreement and imperiled the relationship between the Government of Alberta and First Nations. As the Minister sits down to renew the protocol agreement, one of you please jump.
Honourable members, 29-2A is available. The Honourable Member for Edmonton Strathcona.
Thank you, Mr. Speaker. I would be very pleased to hear what it is the member from Beverly Clareview, I'm sorry, think should happen when the Minister sits down to deal with the protocol agreement.
Honourable Member.
Thank you, Member for Edmonton Strathcona. And so to answer that question, I mean, first and foremost, when the Minister sits down, well, first of all, the Minister needs to engage in meaningful consultation with the various First Nations and to treat them as equals and to have more than just meetings or discussions. You know, I mean, further to that, the different treaties and several First Nations have put forward year after year, going back to, well, I'm sure long before 2006, but I know that there are letters from Treaty 6 with what they would like included in consultation, that their idea of how consultation should unfold. And in conversations with Treaty 6, I know that their proposals have been continuously rejected by this government. Mr. Speaker, another reason why this bill should be completely withdrawn is that myself and other members of this Assembly have made and proposed amendments to the Committee of the Whole that were done in consultation with First Nations that this PC government chose to reject and voted down. I called specifically for ensuring the Consultation Levy Fund is large enough to cover all costs associated with consultation as well as capacity building. I called for a firm statement that levy funds will never be considered accommodation or compensation for infringements upon treaty rights. I called for negotiations between First Nations and the government to determine the amount of the levy as opposed to being unilaterally decided by this PC government. I called for the removal of the clause exempting proponents from paying the levy. And I supported other good amendments that were brought forward by other members of this House. Mr. Speaker, in summary, I strongly urge all members of the Assembly to oppose this bill in its third reading, as many Albertans, many First Nations representatives and leaders have very vocally opposed this bill in its entirety. This bill goes against the will of the very people that it was written to help and to help. And so, Mr. Speaker, if we want to respect First Nations, if we want to respect the will of the First Nations leaders, chiefs and grand chiefs, then this bill should not see the light of day. It should not pass through third reading. And it is our responsibility to listen to and respect the voices of those who we are elected to represent. Thank you very much, Mr. Speaker.